Nice to meet you all. First and foremost, I would like to express my gratitude to WIPO and Latvian Patent Office for extending an invitation to address this esteemed audience. I'm here to present two trademark cases from recent Latvian legal practice. The first case, Vilgarts versus the Patent Office, revolved around trademark registration, while the second case, involving the Sigulda city municipality, pertained to trademark infringement. The outcome of the first case was determined through a court judgment, while the parties involved in the second one reached a settlement. The company Vilgart filed an application with the Patent Office seeking the registration of more than law for services falling under Class 45, specifically legal services. The Patent Office rejected the registration. The Board of Appeal subsequently dismissed the applicant's appeal. The ground of refusal were that the applied for trademark lacked distinctive character in relation to the services for which it was intended. Company Vilgart then initiated legal action seeking to compel the patent offices to register the more than law trademark. According to the applicant claim, they state that the applied for sign possessed distinctiveness. The presence of the word law in the trademark did not necessarily pertain only to legal services. The trademark had multiple interpretations and required interpretation to be understood fully. The Latvian translation of the mark more than law was abstract, inviting various associations and interpretations. Even if the trademark were categorized as an advertising slogan or a reference to quality, this alone should not justify refusal. The Court of First Instance dismissed the action on the grounds that the applied for sign was merely a slogan devoid of distinctive character. The Court of Appeal concurred with the reasoning of the Court of First Instance. The Court reasoned that the legal services are provided to a broad range of consumers, including well-informed, observant, and conscious Latvian consumer, and the word combination more than law could be perceived as a concise sentence, essentially constituting a slogan. The English word law has several meanings, all of which are specific to the practice of law, such as law, jurisprudence, rights, and justice. The meaning depends on the context in which it is used, and in this instance, the Latvian consumer would interpret law in its broad sense, associating it with legal services. Consumer would perceive the applied for sign as denoting something beyond with what a typical lawyer offers, more than just legal services or not limited to rights alone. The court also reasons that sign is not abstract or imaginative, lacked elements of wordplay, conceptual intrigue, or surprise, and did not necessitate cognitive processing of interpretation from the public. It was deemed to be an advertising in laudatory nature, indicated that the applicants offering were more comprehensive and of higher quality than those of other law firms. Consequently, the court concludes that the registration of the trademark must be refused due to its lack of distinctive character concerning the applied for services, namely legal services. This case marks the first instance and first time in Latvia where the court had to provide clarifications regarding slogans and their potential for trademark registration. In the judgment, Court of First Instance and the Court of Appeal also referred to European Court of Justice cases. I will not mention it there in the slides. Moving to the second case, it was a very interesting case, and I hope that we will have time for discussion because I addressed question to auditory about this. Municipality of Sigulda registered trademark. As you can see on the slide, a letter S with sign and in orange color. The claimant registered this trademark for goods in class 16, including advertising materials and services in class 35 for advertising. 5 years had not yet passed since its registration. During the parliamentary election campaign, which was held in previous year, the political party Stabilitate began using this trademark in various forms in its advertising materials, on tents, and on political party office window. You can see how it looked. Unfortunately, it's not in good quality because I didn't have it in the digital format. It was present by pictures which was printed out. The court granted preliminary injunction based on the following consideration. As explained by the plaintiff, the trademark was also used to grant the right to companies associated with the territory of the municipality of Sigulda to use the trademark as indication of their connection with the municipality. This usage could be categorized as advertising provision of services under class 35 of the NIS classification. The plaintiff also employed the trademark when selling souvenirs and accessories featuring the trademark, which could be interpreted as use of the trademark in class 35 for souvenir and accessory sales. The court decided that defendant used the designation in their promotional matter in signage. Consequently, the judge believed that the defendant was using the plaintiff trademark for similar services and goods for which it was registered. In this specific case, any resident of Latvia could be considered a potential consumer, and the defendant's use of the designation, in the judge's opinion, could lead to confusion between the signs. The court decision was influenced by the findings of the Court of Justice in case C379/14, which pertained to the use of sign identical to a trademark in the course of trade. The court clarified that such use occurs when it is conducted within the scope of an activity with the intent of gaining an economic benefit and not a personal capacity. This clarification affirmed that the exclusive right of trademark owners cannot be enforced against personal private use of trademarks. However, exception could be applied to any other type of use if it is linked to economic gain. In the National Court view, obtaining economic benefit was a broader concept than making a profit, encompassing a wider range of subjects, including political parties. Economic benefit could also be derived by individuals who were not engaged in commerce, but whose successful activity could result in economic gain as a byproduct. In the case at hand, this could involve the collection of donations. Thus, by employing the plaintiff trademark, the defendant could attract donors who, upon identifying the defendant's association with the municipality of Sigulda-Jurkāne, might be motivated to donate to the defendant, ultimately leading to the economic gain. Subsequently, the case between the parties was resolved through a settlement. We don't know what will be happened if this case will go to Supreme Court and what will be outcome. Subsequently, I personally came across, it was my case, relevant decisions of European Union countries, and I found just one decision of the Court of Rome, which was delivered in 2021, involving two political parties, where the claimant had registered a trademark identical to their party name, Partito Liberale Italiano, and the defendant sought to use the party name Partito Liberale Europeo. The court ruled in favor of the claimant, finding trademark infringement based on likelihood of confusion. Thank you for attention.
Thank you to Ms. Inga Krigena-Jurkāne. Now you have already one question to thought about. But now we will move from Latvia to Lithuania. And we have Honorable Judge Asta Pikelienė. She represents Civil Division of Vilnius Regional Court. And she's judge since 2010. And the last few years, she's specializing also in intellectual property cases. Please, the floor is yours, Asta.
Thank you. So good afternoon to everyone. And I would like to say thank you for the invitation. And I would like to present one of the latest cases of the Supreme Court of Lithuania, which is related with the distinctiveness of the signs. As you can see in the slide, the dispute was about two marks in Lithuania. It is Gerīt-Katilas and Geras Katilas. In English, it is good boilers and good boiler. So I will use English version. So the main facts of the case. The plaintiff registered domain good boilers in 2009 and in 2018 registered the graphic mark. Defendants registered domain good boiler in 2017, and also defendant's director applied to the trademark registration in 2020. But the patent office satisfied the protest and didn't register the trademark, considering the likelihood of confusion. So the plaintiff asked the court to forbid the defendant from using the domain good boiler and the sign good boiler in its activities, and also asked to recognize the plaintiff rights to defendant's domain good boiler by transferring this domain to the plaintiff. So the first instance court, Vilnius Regional Court, reacted the claim, and court decided that the sign good in singular or in plural is a weak element that doesn't have a solid distinctive character, doesn't perform any identification function, marks the characteristic of the relevant services or goods. Also, the word boiler can be used commercially to describe a specific product traded by dispute parties, and he has no distinctive character and is essentially descriptive. Also noted that the use of this word in the domain names justifies activities related to the sale of specific devices, but the elements good and boiler are not protectable in the plaintiff's trademark. So the appeal court made the opposite decision, and according to the appeal court, the trademarks good boiler and good boilers contains identical dominant verbal elements, describe identical goods, and due to identity of the signs, the same general impression, the majority of the public is confused. Also noted that the plaintiff's mark good boilers yet acquired a distinctiveness through use in e-commerce, and also concluded that the defendants unfairly used the similarity of the mark, infringing its distinctive character. Later on, the Supreme Court of Lithuania referred the case to the Court of Appeal of Lithuania for re-examination, and the Supreme Court stated that proving the trademark's distinctiveness in the competition law doesn't fundamentally differ from the standards of proving the distinctiveness of trademarks or their constituent elements according to the law of trademarks. The acquisition of a distinctive character by use must be evaluated considering the goods or services for which registration of the mark is sought, and second, how an average can perceive the category of goods or services reasonably informed and reasonably observant user. Also, the court noted that trademark use also includes cases where the trademark owner uses it as a domain name, and the evidence relating to the use of the domain name must be evaluated in determining whether the trademark has acquired a distinctive character due to its use. And information such as the number of visits to the internet owner's website, the ranking of this website in terms of the frequency of visits from different countries, or the number of times the trademark has been searched through internet search engines are data that can help to prove that the trademark has acquired a distinctive character through use. Also, Supreme Court emphasized that confusion between marks differing by two letters, meaning plural or singular, is natural, but this doesn't in any way indicate that the trademark good boilers has acquired a distinctive character due to use. The fact that there is a possibility of misleading the public doesn't mean that the trademark good boilers has acquired a distinctive character through use. Non-distinctive signs are not protected by trademark or competition law, inter alia, against the possibility of confusion. And finally, the Court of Appeal of Lithuania left the decision of the Court of First Instance unchanged and stated that the plaintiff didn't prove that the mark good boilers used in its domain acquired a distinctive character due to use, that the evidence provided by the plaintiff doesn't confirm that a large part of the public associated this mark specifically with the plaintiff's commercial activities, that the mark was used for a long time, widely and intensively, that the plaintiff made significant investments, as a result of which the mark is perceived as an explicit identifier of the plaintiff's business. Also, court noted that there is no data that allows to recognize that a significant part of consumers would associate the sign good boilers with the goods and services offered by the plaintiff. And the data provided by the plaintiff confirmed the existence of continuous commercial relations in operation and through the domain good boilers, but not the circumstance that it became recognizable and widely known precisely through the sign good boilers that forms the name of this domain. Thank you for your attention.
Thank you, Ms. Pikelienė. And now we are going to move to Estonia. I ask Ms. Lepik to make the presentation. Gea represents Civil Chamber in Tallinn Circuit Court. She is working as a judge since August 2021. Before, she has worked for 5 years at the Estonian Ministry of Justice, and she was responsible for transposing the recent trademark directive in Estonian law. And actually, she has been lecturer for intellectual property at the University of Tartu since 2015. Please, Kim.
Yes,
go.
Thank you. I'm also very happy and grateful to be here. And unfortunately, I had to skip a class at the University of Tartu today, so my students may not be that happy, but we will meet with them at some other time. I will today present 2 cases from the practice of the Estonian Supreme Court from the last years. One of them is from 2021 and the other is from 2020, but they, in my view, are the most relevant cases in the past 3 years. There hasn't been anything newer since April 2021, so our Supreme Court has not said much about IP in the recent years. Hopefully, it will change soon. My first case is about trademarks. And in this case, which was made in 2021, the Supreme Court explained the liability of an aider, or a so-called accomplice, in a trademark infringement, and the claim for lost profits as compensation for damages. Briefly about the facts. SNBR is a global organization which represents brand owners of very famous brands. Some of them are listed on the slides. And all these brand owners have registered trademarks, which are valid in Estonia and in the US. The Estonian marks were either a national trademark or an EU trademark, and in some cases, international registration. On the internet, however, there were a number of domain names in which signs identical to the brand owner's trademarks were used, and which led to websites where counterfeit goods were sold. So this organization, SNBR, found out that a person, a private person, we call them DM, was the owner of the IP addresses corresponding to these domain names and websites. And it turned out that this natural person had registered thousands of IP addresses and then rented these addresses to individuals who had linked them to domain names and started selling counterfeit goods on these domains. So SNBR was of the opinion that despite the fact that DM did not itself register the domain names and did not sell counterfeit products on the websites, it was responsible for the infringement of the brand owner's trademarks in these domain names and websites, as it provided a service that was used for infringing the trademarks, and which enabled the registrant of the domain names and thus the managers of the online stores to remain anonymous. SNBR contacted DM regarding this infringement, but the DM did not react. Thus, SNBR filed a claim to court demanding termination of the infringement and compensation for the damages caused to its members. And the damages included lost revenue, as the infringement had allegedly damaged the brand's reputation and led to a loss of sales. The county court dismissed the claim. The circuit court satisfied the claim for termination of the infringement, but not for damages. And the Supreme Court annulled the decisions of the lower instance courts with respect to the claim for damages and referred the matter back to the county court for a new hearing regarding the damages claim. The Supreme Court agreed with the lower instance courts that under the circumstances of this case, DM was jointly liable with the direct infringers for the damage caused to trademark owners. There was no dispute that the defendant did not sell counterfeit goods himself. However, the courts had established that his services were necessary for linking the IP addresses with domain names on which the e-stores selling the counterfeit goods could be accessed, and thus these services were necessary for infringing the trademarks. The Supreme Court held that the defendant had an obligation to act from the moment he was informed of illegal activities in order to prevent the infringements on the websites. And by failing to do this, the defendant had knowingly and intentionally contributed to illegal activities and must be regarded as an aider in the infringement. Pursuant to Estonian Law of Obligations Act, I have cited the provision on the slide, the behavior of an aider is considered equal to the behavior of the person who caused the damage, and they are both jointly and severally liable for the damage. So the Supreme Court found that the lower courts had unjustifiably dismissed SNBR's claim for damages, finding that it had not brought forward and proven the necessary facts. Under Estonian law, in general, if the claimant is claiming compensation for lost profits, he is required to prove the circumstances from which it appears that he would have likely received profits. For example, or meaning that he had the intention and also the opportunity to receive them. In this case, the plaintiff relied on Section 6 of paragraph 127 of the Law of Obligations Act, which states that if compensation for damages is claimed due to infringement of IP rights, a court may, if reasonable, determine compensation for damages as a specific amount. The Supreme Court found that proving lost profits of a trademark owner due to sales of counterfeit products is extremely difficult or even impossible. The assessment is based on probability, and in most cases, it is simply not possible to accurately assess the profits a person would have received if his rights had not been infringed. Requiring a specific calculation of damages in such cases could result in lost profits not being compensated at all in trademark infringement cases, which, in the opinion of the court, would be contrary to the purpose of the Law of Obligations Act and also the EU Enforcement Directive. Thus, the Supreme Court held that in situations where it is not possible to calculate specific damages, the lost profits of a trademark owner can be calculated abstractly, meaning that the trademark owner can claim profits that can usually be expected in similar circumstances. And one way to calculate abstract damages is to apply a so-called license analogy, that is, determining the compensation based on a hypothetical license fee. This approach does not require that the right owner has actually granted licenses in the past, but it only still works when granting licenses is common in the relevant trade. In the current case, the plaintiff could not provide data on usual license fees because it is likely that no licenses are granted for the sale of counterfeit goods. So as an alternative to hypothetical license fees, the Supreme Court argued that right owners can also present other circumstances that would allow the courts to determine the lost profits. For example, the claimant could present research or data on how much revenue is typically lost in a particular field due to sales of counterfeit goods. The other party can in turn prove that under current circumstances, the injured party would not have earned such profits. The court added that it is possible to also take into account the turnover or profit of the infringer. And although the infringer's profit or turnover cannot be equated with lost profits of the trademark owner, it may still serve as a starting point for calculating the justified amount of damages. And the second case I would like to introduce to you concerns copyright protection. And the relevance of the case is that it explains the concept of originality of a work, the scope of implied licenses, and also the claim of unjustified enrichment, enabling the right owner to claim the revenue received by an infringer. So in this case, it concerned a very famous Estonian composer called Ivar Must. Mr. Must had composed a melody in 1994 for use in a television advertising clip by a company called Põltsamaa, which produces juices, jams, and similar products. The parties had not concluded a written agreement, and it was not possible to establish the precise terms of their agreement regarding ownership and use of copyright in the melody that Mr. Must had created. In 2016, Mr. Must filed a claim in court, arguing copyright infringement for the reason that since 1994, the defendant had used a part of his work and arrangements made from it in numerous other advertising clips without Mr. Must's consent and without paying any royalties. The courts established that the length of the sound file of the 1994 advertising clip was approximately 26 seconds, but the part of the work which was arguably used by the defendant without the author's consent was only the music behind the final textual phrase, Põltsamaa, genuine and good, and this constituted only 2 bars, which was 8 notes. In this case, the Supreme Court thoroughly examined the concept of originality and when the use of part of a work, that is 8 notes, constitutes infringement of copyright. The court stated that the Estonian Copyright Act must follow, when interpreting the meaning of a work under Estonian copyright law, we must follow the case law of the Court of Justice of the European Union on the InfoSoc directive. And the court referred to the judgments of the Court of Justice in several cases, like Levola Hengelo, Kofemel, Painter, and the case law referred to in those judgments, and stated that in order for an object to be classified as a work, it must be original in the sense that it is the expression of the author's own intellectual creation, meaning that it must reflect the author's personality and reveal his free and creative choices. Referring to the Infopack international case, the Supreme Court held that whether the use of the 2-bar musical phrase at issue infringes the claimant's rights depends on whether it corresponds to the characteristics of a work. The court agreed with the defendant that the recognizability of the work or part thereof is not a separate precondition for copyright protection, but noted that the Court of Justice has considered important that the work reflects the author's personality. And the fact that a part of a work is clearly identifiable and attributable to a particular work or author may indicate that it bears the personal touch of a particular author. In the opinion of the Supreme Court, the Circuit Court had duly substantiated its conclusion that the disputed 2-bar sound clip was protected by copyright, relying on the opinions of several music experts. Although the defendant argued that the disputed melody was a common technique in music and that number and rhythm of its notes were due to the peculiarities of the Estonian language, the Circuit Court had established that the disputed part, that is the Dubar sound clip, was recognizable and contained the author's original creation. In this case, the Supreme Court also emphasized that the uniqueness of the work, in the sense that nothing like it has been created in the world so far, is not a precondition for copyright protection. The second important issue addressed in this case was how to determine the scope of a license to use a copyrighted work in a situation where there was no dispute that Mr. Must had, in principle, agreed to the use of his work in an advertising, but there was disagreement as to the extent, also the time span of this use. I will not go thoroughly into this because I have time constraints, but the main findings are shown on the slide. Rather, I will address the third issue that the Supreme Court addressed in this case. Namely, it clarified the copyright owner's claim for transfer of the revenue received as a result of the infringement. Pursuant to the Estonian Law of Obligations Act, the entitled person may demand that a violator who is or should be aware of the lack of justification for the violation transfer any revenue received as a result of the violation. And this transfer of revenue can be claimed in addition to any damages suffered by the right owner himself. So in addition to his own damages, he can claim whatever the infringer has received. And the Supreme Court found that the amount of the claim for transfer of revenue can be based on the defendant's sales revenue, but certain deductions can be made from it. First, the defendant can deduct direct expenses incurred to obtain the revenue. For example, the price paid for infringing the goods, or price paid for producing or buying the infringing goods, any transportation costs and other direct expenses without which they would not have received the revenue. But also the defendant can point out other circumstances that affect the amount of revenue that the defendant received due to the violation. For example, it can generally be assumed that the income from the sale of the product, in this case the juices and the jams, does not result solely from the advertisement of the product or the music used in the advertisement. But other circumstances also play a role in obtaining the revenue. And for example, in the current case, the defendant had claimed and presented evidence in the proceedings that in the food industry, product sales and revenue depend on many other factors as well, including the product itself and the reputation of the brand and manufacturer, and the advertising is only one of the many activities carried out to promote product sales. Supreme Court also noted that in the event that determining the exact amount of the revenue that the defendant has received as a result of the infringement is unreasonably difficult, the court may, according to our Code of Civil Procedure, decide the amount of compensation in accordance with its inner conviction, considering all the relevant circumstances. So, thank you for my part. These were the two most relevant recent Supreme Court judgments from Estonia.
Thank you, Gail. And now we are going to move to Poland. We have a Honorable Judge Jarosław Antoniuk. He represents Circuit Court in Katowice. He is Doctor of Law. He is a judge about 18 years already, and he is a lecturer at Silesian University of Technology. He will present Polish case on copyright, as I understood. Okay, please, the floor is yours.
Thank you very much. Firstly, I want to thank you for inviting me to this seminar. It's a great pleasure for me to be here with you, and especially that is the first time when I'm in Latvia. And secondly, I want to thank you, Professor Alexander von Milan-Dahl, who is absent, that he was so kind and yesterday told you about this case, what I am going to tell you about. My situation is quite easy in this situation because you have seen the request for preliminary ruling, and you have seen yesterday the decision of the Court of Justice in the case of Kostroma Polska. I will be only talking about this national law context of this case and backgrounds, and of course about conclusions in the context of this decision of the Court of Justice, especially influence of this decision to the practice of the courts and the member states countries. Okay. Firstly, I would like to say that according to the Polish legal literature, it's commonly accepted that we have three levels, 2 degrees of standard of proof. We can say also that this judicial convention. The first one is certainty, and the second is higher plausibility. Also, we can say that is higher probability, and the last one is mere plausibility, or how you prefer, mere probability. This certainty, according this is the rule, and the both it means that high probability and mere probability are the exceptions. So in such situation, must be explicit in the rules that this is the lower standard of proof. It's important to say that from the 1st July of 2020, we create in Poland specialized courts specialized in intellectual property rights. And also from this moment, we amended the Polish procedure, civil Polish procedure, and is inside this wide amendment. There was the second implementation to the Polish law, Article 8 of Enforced Directive, which you can see yesterday also, but you can see also now. And before that, this regulation was in separate acts, which were regulating all the time the exclusive rights. Now we have one regulation, which is in Article 479 with the number 112, and 479 with the number 121 of Polish civil procedure. But it's a little problem, I can say, with this regulation, because according to this Article 479 with the number 113, paragraph 1, is the requirement that the applicant must, or she or he, must credibly demonstrate the circumstances indicating the infringement of the rights as a requirement of granting request for information. So this phrase in this article is unknown to Polish legislator before, and it's controversial, especially in Polish doctrine. According part of the authors says that it's certainty. Part of the authors say that we are talking about probability. Part of them says that it's high probability. So in circuit court in Warsaw is pending all the time. I want that it should be clear, is pending the case in which TB against Kostroma Polska and KNOR, in which TB is requesting for the information about especially networks of distribution, channels of distribution, information about prices, and information about list of suppliers, etc., etc. And it's all about graphics which were sold by the Kostroma and were produced by the KNOR. KNOR is a producer of some graphics in frames just for Kostroma. And TB is a natural person, and she markets decorative articles, and she is the author of 3 graphics, which you can see yesterday, 2 of them, A, B, and C, and with the sentences, which means my house, my rules, perfect people don't exist, and yet here I am, and in our house, the patter of tiny feet can be heard in the morning. It always smells like delicious cake. We have a lot of chores, a lot of fun, and lots of love. They looks like that. This first to one, it means A and B were reproduced identical by the Knorr, and this third one, it is the C, was reproduced by a little changes. TB said that she is a creator of this image, and in her opinion, in her view, this works are works in the meaning of Article 1, Paragraph 1 of Polish Copyright Act, and this reproduction of this graphics were sold both in bricks and mortar shops and online shops of Castorama, and was produced by Knorr. And what is important, of course, neither the reproductions and issue in the proceedings, nor the images themselves has name and surname of the TB, and of course there is no consent of TB for such dissemination and reproducing her graphics. And TB stated that she held an economic and, of course, moral copyright to these images, which were reproduced by Castorama, by Knorr, sold by Castorama, and is why in the purpose of bringing the action of infringement of copyright, she needs an information to know about the amount of damage which was a result of this infringement. And what is important is important which evidence were offered by TB. TB offered only the court print screens of the websites and invoices. And well, Castorama generally opinion is that these works are not works in the meaning of Article 1 of the Copyright Act, because there is a lack of novelty and originality. In the opinion of Castorama Polska, there are simplified motivational artworks with 3 sentences. And in this situation, with the, well, offer not a lot of evidence, Circuit Court in Warsaw decided that will request the Court of Justice of the European Union for the interpretation of Article 8 of the Enforcement Directive. We must remember that, of course, this Article 479 with the number 113 should be interpreted together with in the context of Article 8 of the Enforcement Directive. So, in fact, the Circuit Court in Warsaw wanted to, well, expect that the Court of Justice will help in interpretation this controversial phrase in the Polish regulation. The request for preliminary ruling is a little bit complicated, but because, in fact, the Circuit Court in Warsaw asked about, especially in the point 1, if that must be decided before granting request for information, the matter existing rights in separate proceeding, and but the Court of Justice recognized that, in fact, the question is of the Circuit Court in Warsaw is that interpretation of the standard of proof according to the Article 8 of Enforcement Directive. So, well, the opinion of the judgment of Court of Justice is that this Article 8, Paragraph 1 of the Enforcement Directive must be interpreted as meaning that in proceedings concerning an infringement of an intellectual property right under the provision, the applicant must, for the purpose of a request for information under Article 8 of Directive, Enforcement Directive, provide any reasonable available evidence enabling the court seized of the request to satisfy itself with a sufficient degree of certainty
that the applicant is the rights holder by submitting evidence appropriate to the nature of the right and any special applicable formalities. So for me, it's not clear and it's not completely satisfying me, this judgment in this sense, but that I expected as a judge that it will be told by the court that it's one of these three standards of proof. But this answer of the Court of Justice is a consequence of the question of the this request for preliminary ruling from the Circuit Court in Warsaw. But what is important that the court said distinguished the standard of proof according to the Article 8 enforcement directive from the standard of proof in the cases which issue is the infringement of law, when this infringement, and also of course being a holder of rights, must be proved. So it's obvious that we are not talking in the context of Article 8, we are not talking about certainty, we are talking about probability. The question, of course, is if we are talking about probability, mere probability, or high probability. So according this, well, my understanding, this what was said by the court, that the court has a reasonable certain of an existence of an exclusive right. In my opinion, is we are talking about high probability, and in the context of Article 8 of Enforcement Directive. And what it means that mere probability is insufficient to decide to grant a request for information according to the Article 8 of this directive. Thank you very much for your attention.
Okay, thank you. Mr. Antoniuk, now maybe we have some minutes for questions. Do we have some questions from audience? Or if no, then I will ask the question asked by Ms. Inga Krigena-Jurkāne. Okay, the question was, and I will read not to miss some important words. If a political party uses during the pre-election campaign a trademark belonging to another person, can it be perceived as a use of the trademark in the course of trade in the sense of Article 10 of the Trademark Directive? Okay, are you ready to answer to this question?
So maybe I start, because it seems to be that answer for this question is simple for me, because according to the, I think the problem in this case is it was if this trademark was used in the commercial course. But according to the Polish regulation is industrial property law, the monopoly is to use the trademark in purpose of profits. So not strictly in commercial use. So for me, in the Polish court, it would be simpler to say that the party used this trademark just in the purpose for profits, especially as a donation for the citizens for the party. So it could be qualified as the infringement of the trademark in this aspect.
Yes, I would also agree. We haven't had a similar case in Estonia, not to my knowledge at least, but I would draw a distinction between like private sphere and then public sphere, and then there is a separate question whether the use in the public sphere needs to gain economic benefit. But I would see that as a wide criteria, because you would in any case have to ascertain that the use was regarding goods or services, that there was a harm to the functions of the trademark. So there's actually, it wouldn't make sense to limit the notion of use in course of trade too much, because there are other criteria that also have to be gone through before you establish infringement. And definitely this use was in the public sphere, and in the current case you could also find like profit like from donations, or even probably other types of profit. So yes, I would say it's in the course of trade.
Okay, would you like to add something? Yeah, okay.
No. So in Lithuania we also don't have such cases, but I probably will agree with them that the sign couldn't be used in the commercial area.
Okay, thank you for answering this question. Okay, yeah, we have more question.
Yes, thank you. No, regarding this last case, that the maybe interesting aspect was that the political party had not registered their trademark, and they're actually in the process of trying to register that trademark when all of that was happening. But that's just bystanding information.
While during proceeding, they applied for 2 or 3 trademarks in patent office, this political party, and one of them was very similar to this register one. As this one, they, according to settlement, took back the application. It was written in settlement, but I didn't check. Thank you.
Yes, it was. In the settlement, they agreed with the party that they will not use it in any form and way, and in the future. My question was actually regarding the Estonian case. I was just, maybe if I missed it, the first one, which was quite interesting regarding the damages. What I missed maybe at the end. So did they actually in practice manage to come to amount of damages in that specific case, where, you know, when there are counterfeit products which are sold, which you said that there is a difficulty and there are 2 criteria, and did they come to a possibility to come to an amount which then the court decided on?
Yes, thank you. This was the Supreme Court's judgment. They just gave directions on how to apply the law, and they sent it back to the lower courts. And unfortunately, I'm not exactly sure what the end result was. But I can check it out and email you the answer.
Thank you. This will be actually subject of your presentation in the next seminar. How the case was finished. Okay, do you have more questions at the moment? No, it seems no. Then I would like to once more thank to the judges that they agreed to prepare the presentation and agreed to come here and present it. Thank you very much once more.